Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, the Florida Bar says I have to give you a legal disclaimer. This podcast isn't legal advice. So I've said it, but nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games the carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Shoulder disabilities can be extremely difficult to work around, if you will. That's because we use our shoulders in front of us, above us, to the side, and a lack of mobility or stiffness can impact not only the use of that particular extremity, the affected extremity, but it also affects the use of both of your shoulders, which is called bilateral manual dexterity. That is really important in an ERISA disability claim, and that's what we're going to talk about today. Specifically, I'm going to talk about, can you get long-term disability benefits for shoulder problems? Second, I'm going to tell you the story about how MetLife applied a musculoskeletal and soft tissue disorder limitation to a shoulder surgery case. And I'm also going to talk to you about how disability carriers will use medical improvement and shoulder injuries or conditions to terminate disability benefits. Ready? Well, I think this is going to be an exciting episode, but let's take a break before we get started, okay?
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos regarding your disability application that will assist you in submitting a winning disability application. This is one you won't want to miss. For the next 24 hours, we are giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.
Welcome back to Winning Isn't Easy. Medical improvement of a labral tear of the shoulder and termination of long-term disability benefits. What you need to know. Now, disability carriers are always looking for a reason to deny or terminate benefits. One of the prime reasons they'll use to terminate benefits is the argument that you have been at what's called maximum medical improvement and you're no longer disabled. Now, disability carriers are rarely getting your medical records, and they're asking your physician to complete these forms called attending physician statement forms. Your records and your APS forms are then reviewed by their physicians for signs of improvement or objective medical findings on examination and testing that are consistent with what's called maximum medical improvement. Maximum medical improvement means that you've gotten as well as you're going to get. Now, additionally, they ask you to complete activities of daily living forms to comment on your activity level. Now, disability carriers will often equate increased activity levels as evidence of maximum medical improvement. They're going to call you, they're going to talk about your claim, and that's not a social call. They're asking you whether you've improved, whether you've increased your activity level, and you have to be careful about how you answer those questions. If you say, I'm fine, I'm improving, and they don't ask any follow-up questions to kind of drag out from you the symptoms that you're having, they're going to interpret that as evidence of improvement, because after all, that's what you said. So your medical records, the APS forms that your physician completes, and your activity of daily living forms are all fodder. They're fodder for the carrier to argue that there's been medical improvement and the basis for justifying a termination of benefits. And that's what happened in the case of Hall versus AT&T umbrella benefit plan. It's a case out of the Northern District of California. Hall was a testing tech, had an impingement and an acromioclavicular arthropathy with a labral tear in the right shoulder. Shoulder's messed up. She underwent 2 shoulder surgeries. She even had physical therapy. Now, her range of motion improved, but she claimed that there was no change in her pain or functionality. Her doctor said she couldn't reach at or above shoulder height. She was limited to lifting no more than 15 pounds, and she had limited ability to flex and extend her neck and couldn't work. Now, part of the problem starts with the fact that her cervical spine examinations were normal, as was a cervical MRI and electrodiagnostic studies known as an EMG and nerve conduction study test. So from a cervical standpoint, there's not a lot there, and there's not a lot that is showing up in terms of objective evidence, if you will, of radicular symptoms. The carrier paid benefits for 2 years, and after that, they denied benefits based on a review of the medical records. They concluded that there wasn't any objective basis for the assigned restrictions and limitations. Now, Hall appealed, and ultimately this case ended up in front of a federal judge who noted the lack of objective findings on physical examination, other than the range of motion, and the lack of objective findings on the MRI and the negative electrodiagnostic studies. The judge ultimately agreed that there was evidence of improvement and that was sufficient to support the claims denial. But there are some lessons learned here. And I think that these are important and applicable to all sorts of medical conditions, just not shoulders. When your claim is denied, you have generally 180 days in which to file an appeal. That appeal is the trial of your case. And so what you should be doing is, for example, undergoing a functional capacity exam to establish your restrictions and limitations and an objective basis of those restrictions and limitations. You want your physician to document and comment on objective findings and the diagnostic studies to support the restrictions and limitations, or explain why the absence of objective findings is not the equivalent of improvement. Now, if your physician won't cooperate, won't play ball, you should undergo your own independent medical examination to address the issues. And you should only do that in consultation with an experienced lawyer who knows what doctor to send you to, and a doctor that will play ball and answer questions. You should be preparing a statement that outlines the lack of your functional improvement, notwithstanding the treatment that you've gotten. And ultimately, of course, we want your doctor to endorse the FCE, explain the objective findings or the lack of objective findings, explain why the restrictions and limitations are still valid, and rebut the opinions of the liar for hire doctor that the disability carrier is hired for the sole purpose of terminating your benefits. And of course, you should be hiring an experienced ERISA disability attorney to document factually and medically why there has been no improvement. Remember, you've got the burden of proof, and that appeal is the trial of your case. Please, please don't let the disability carrier play the maximum medical improvement game and deny your claim or terminate your benefits. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you enjoyed this episode, consider liking our page, leaving a review, or sharing it with your family or friend. And you should be subscribing to this podcast. That way you're going to get notification every time a new episode comes out. I hope you tune in to our next episode of Winning Isn't Easy. Thanks.